Just make you aware of that. And just before we get started too, I just want to make a note that we're providing kind of a general overview of some of the basics of land use planning and regulation in Vermont. We're not able to provide legal advice on planning and zoning matters. So for those legal questions, always refer to your town attorney for assistance with those. We have 4 sections we're going to cover shown here. So we'll be talking about planning for your community, where we'll be covering some of the state planning context and the town development process, town plan development process. Implementing the plan, I'll be talking about both regulatory and non-regulatory ways to implement a town plan. Roles and responsibilities looks at the different boards and committees within your community that are working on planning and zoning, and also the role of municipal staff. And then the final section talks about more procedural requirements for meetings and public hearings, open meeting law requirements, and potential conflicts of interest too.
Did you pee? Did you do that? Did you?
I'm gonna just mute everyone for now. And what I'll do too, as we go through the presentation, because we have these 4 different sections, after each section, I'll give everyone a chance if you have questions on that specific section before moving on to the next one. We'll pause and give everyone a chance to ask questions. When you have a chance as well, if people wouldn't mind just in the chat box, just providing your name and which town you're from. That's helpful for us just to know which towns in our region are represented here this afternoon. So again, thank you for attending, and I'll get started here. So the first section we'll look at is planning for your community. It's important to keep in mind that Vermont is a Dillon rule state. So this means that towns can only do things that are enabled by statute. And the statute also includes things that towns must do in terms of their planning and zoning requirements. So most provisions in statute related to land use planning are found in the Municipal and Regional Planning and Development Act. And the state has a very easy to navigate website where all the statutes can be found. And so I would just recommend you kind of save the state statutes, that website, as a favorite in your browser, and just to refer back to that regularly. Because we need to, towns need to keep in mind those provisions when it comes to planning and zoning. So in terms of the elements of land use planning and regulation, so statute is what authorizes the types of plans that towns can adopt, and implementation steps that they can take to implement their plans. Municipal plans are authorized under statute, so towns are allowed to develop municipal plans. Statute does require certain plan elements or chapters are included within your town plan. And then the state also has outcome goals for plans, so broad goals that plans should be addressing to meet statewide planning goals. Implementation tools, again, these are provided for under statute. So these include regulatory tools, so that's zoning, subdivision bylaws, flood hazard area regulations, and then also non-regulatory tools. So that could be a capital improvement plan for making public investments in your community. And we'll talk about all of these in more detail. So Probably most of you are familiar with the municipal plan or the town plan, but just quickly to go over what this document is. It helps define a community's vision for its future. It should be primarily looking forward. Town plans are required to be updated every 8 years. So it's a community's chance to look out kind of in that time horizon of 5 to 8 years. Of course, it's important to provide context as well, looking at what are the existing conditions, what has changed since the last time the town plan was updated, what are the current issues and concerns, and then building on that, developing a vision for the future. The vision is kind of the broad direction the community wants to go in, and the plan also provides guidance for how to achieve those goals through things like land use regulations and public investments, other actions. So that could include further studies, that could include forming advisory committees, and it provides policies for orderly growth and development, especially for projects that come under Act 250 or Section 248, the state permitting process. The town plan is referred to, and the policy statements in your town plan are very important during that state review process. So why have a municipal plan? There are statute requirements for what's included in your municipal plan, but it's also important for towns to use this as an opportunity to develop a plan that really meets their specific needs and priorities and values. So it's a way to empower your community to kind of come together and develop a focused plan to respond to changes that are based on your own values in your community. Land use planning in the town plan process is a first step for developing your zoning bylaws and subdivision bylaws. If you have them in place or you're considering adopting zoning, you need to have a town plan in place. And the land use planning process allows you to think about these land use and housing issues kind of at a broad community-wide level, and engage with the public to get feedback on that. And that will help inform your more technical land use regulations in the zoning bylaws and subdivision bylaws. So it's important, the town plan process is important to help as you think about and want to regulate land use and development in your community. It establishes a transparent, consistent, and predictable public policy. So the town plan includes broad goals and objectives and policies and action steps that the town would like to pursue. And that's a document that the public can refer back to and understand the direction the community intends to go in. So it provides more transparency between members of the public, the planning commission, select board, and other municipal boards and committees that are working on implementing the plan. And then it helps promote wise investments and manage future costs. So going through the town planning process allows a town to think about where it wants to make investments in the future, where there are upcoming projects that need to be completed that can help the town budget for those in its capital planning process. So it's a way for the town to think ahead about larger expenses that it needs to plan for, so that a town is not caught off guard by some of those future costs. So some additional benefits, as I mentioned, for a community that has zoning or is wanting to adopt zoning, you need to have a town plan in place. So having a town plan allows you to adopt those local land use regulations. For the Act 250 state permitting process, a project needs to show conformance with the town plan. And again, that's where the policy statements and objectives and goals are especially important, because those are really what are looked at most commonly in the Act 250 process. Under Section 248, which is the state permitting process for renewable energy generation and transmission projects, the recommendations from the town plan are also given consideration in that process. And towns that have a town plan in place are eligible for certain grants from the state, and it can allow you to have a more competitive grant application. So this slide shows the 7 steps of the planning process, and you can see it's cyclical. So it is an ongoing process, town planning. Step 1 in the town plan process is completing that community assessment. So this is where you're really getting a sense of where do we stand today? What is our population? What are the housing characteristics like? How is our local economy? How are people doing in terms of job opportunities and earnings? It's also a chance to look at past planning efforts. What has the town been working on the last several years that's relevant to the town plan that might not be in your current town plan? If the town has done a housing needs assessment, that might need to get incorporated into your town plan. If you did significant changes to your zoning, that might need to be reflected. There are also often large events that happen, such as the July floods of last year, that impacted a lot of communities. And as towns start their town plan update process, the need to address flood resiliency is more critical now for many communities, and that is something that might need to get kind of enhanced within a town plan. So it's looking at those existing conditions. This is also the opportunity to do a lot of the public outreach. So that might be a community survey that's done, hosting a public meeting or series of meetings to get additional input too, beyond just the data that we might get from the state or from the Census Bureau, and to hear directly from members of the community.
Sorry.
Once you have that community assessment, you can start establishing goals and objectives. So you're starting to identify what the issues are and the opportunities, and then you can start creating goals and objectives. And then step 3 is identifying specific policies and action steps to help achieve those different goals and objectives. And I always recommend to towns that in the step 3 process, it's important to be realistic in developing actions for the town, realistic in terms of what the town might be able to accomplish in the next several years, and not take on too much, because that can kind of be overwhelming if there are too many actions the town is trying to take. So I think it's good to be realistic and come up with a manageable number of action steps. Step 4 is creating a program to implement the plan. And this is the process of taking those action steps and starting to figure out who in the community is going to be primarily responsible for this. And some actions are the responsibility of the select board, some of a planning commission, conservation commission. So starting to figure out who should be taking the lead on these, trying to identify a time frame. Some projects are very quick projects that can be completed in the short term. Some projects will take longer to complete. And then we also recommend just thinking about funding resources too. Some projects will be funded just through your town budget. For some projects, there are grant opportunities. And for the implementation program, it can be helpful to show that in a spreadsheet. And that's something that can be referred back to by the community throughout the life of the town plan. Step 5 is the process of adopting the plan, and then you get into implementation. Working on that implementation plan that you created as part of the town plan. And then step 7 is evaluating the plan and plan program, which happens before you start the plan update process again. Once the plan is adopted, the implementation process, this is an ongoing process, and I recommend that towns refer back to their implementation program if it's an annual thing, just to see how they're doing, working on different action steps. And if projects were identified kind of further out, just making sure that towns keep track of projects that they're hoping to work on. And then, we recommend taking 2 years to update your town plan. I think that provides an adequate amount of time. So I think when you're starting to, like I said, the town plan expires every 8 years. So, once you get to 5 to 6 years, starting to think about needing to start that process of updating the plan so you have enough time to complete that. So the state has goals for outcomes for town plans. So things that they want to see communities accomplish in the town planning process, but then there are also planning process goals. So this is more, what's the process a town goes through when it engages in planning? So these are statute goals. Towns need to establish a coordinated and comprehensive planning process and policy framework to guide their decisions. Towns need to encourage citizen participation at all planning levels. They need to consider the use of resources and consequences of growth and development for the region and the state, as well as their own community. And encourage and assist municipalities to work creatively together to develop and implement plans. So encouraging that work between communities as well. And when it comes to engaging in the planning process and public engagement, there are different levels of public engagement outlined on the slide here. So just to go through those, the first level of engagement is informing, and this is keeping residents informed about the planning process. So this might be posting information on your website about upcoming planning commission meetings where you're talking about the town plan update. It could be a newsletter article. It's informing. It's not necessarily seeking input from members of the public, but it's an important part of the planning process to just to inform on how the process is going. Consulting is providing opportunities for input on existing ideas. So listening, acknowledging concerns, and answering questions. So that's often in the form of a survey. You're creating a list of questions and getting feedback on those. Or public meetings where you might be, bringing certain questions or ideas to a meeting to get feedback on. The next level of engagement is involve, and this is providing opportunities for dialogue and interaction and obtaining advice from the public and generating new ideas. So this is more working working more closely with the public to identify those ideas versus just consulting. And then collaborating is the most engaged level. And this is partnering with the public in decision making. And so this could be in the form of a citizen advisory committee working on a specific issue or topic. It could be through a design charrette, which are more engaged and lengthier kind of public discussion and decision-making processes. And I think it's important to, in doing the town plan update and town planning, is picking the right type of engagement for the specific planning process. So, collaboration may be more appropriate for a very detailed follow-up study. If you were working on a village master plan, for example, there might be more of an opportunity for that collaboration. Or if the town wanted to investigate an issue further in more detail out of the town plan process, you might form an advisory committee that spends more time looking at that. And it's good to keep in mind too that these different strategies for public engagement, you can use all of them in the planning process. And there are times when you're going to be informing the public, and other times where you're looking for more sustained involvement and feedback from the public. So just kind of keeping those different things in mind. Let's see. So this next slide shows the planning outcome goals that the state has. So there are 14 statewide goals in state statute. And the statute provides more details on these, each goal, but just to keep it more succinct here, the state, for the town plan, they're looking for the town plan to work towards encouraging compact villages, supporting a strong, diverse economy, providing for education and vocational training, providing for safe and affordable childcare, providing efficient public facilities and services, recreational opportunities, safe and affordable housing, protecting strong agricultural and forest industries, planning for flood resilient communities, ensuring the wise and efficient use of natural resources, preserving natural and historic resources, protecting the quality of air, water, and wildlife resources, providing for safe and convenient transportation, and supporting energy efficiency and allowing for renewable resource opportunities. So to meet the statute requirement, the town plan and communities need to demonstrate that they are working towards achieving these goals. And those 14 statewide planning goals, for the most part, fit under the different town plan elements. And so these are also can be referred to as chapters in your town plan, but these are the different sections that need to be included. So you need to have a statement of objectives, policy, and programs to guide future growth and development and to protect the environment. You need to have a land use plan, transportation plan, community utilities and facilities, a statement of policies on preserving natural areas, scenic and historic resources, educational facilities plan, a recommended program for implementation of objectives. So that's your implementation plan. The plan needs to include a statement of compatibility, just in terms of how the plan relates to adjacent towns and the plans they have, and in the Wyndham Regional Plan. It needs to have an energy plan, and towns now have the option for creating an enhanced energy plan under Act 174. A housing element, economic development, and flood resilience. So those are the different sections that are required to be within a town plan. You don't have to kind of have a separate chapter for each of those. Some town plans will combine some of these sections. Some town plans will take a more thematic approach, where they'll talk about broader categories, where you might have multiple elements falling under those broad categories. And that's fine. You just need to make sure that all these are addressed somewhere in the plan. So the plan adoption process. So as I mentioned, the town plans now expire every 8 years. It used to be 5 years, and so now it's 8 years. So it's important to just be aware of the amount of time you need to complete the town plan update process. The extent of the update is going to depend on if the town completed a very comprehensive update to their town plan during the last update process, or if there have been significant changes in the community. It may be that not much has changed during the 8-year period, and so the update process may be relatively straightforward. But at a minimum, you need to complete updates to the community profile data and then reviewing and updating the implementation program, just to make sure that that is still reflective of what the community is looking to accomplish. It's also important to note that the adoption process can take several months. So plan ahead and thinking about when your town plan expires. So the Planning Commission holds a public hearing on the town plan, and they need to provide 30 days notice to adjacent communities, the state, and to WRC. And then the select board also needs to hold a hearing, and depending on the size of your town, the select board may need to hold 2 public hearings. And then the select board makes a decision on adoption of the plan following the last public hearing. The plan goes into effect once it is adopted by the select board, but that whole process from when a town plan is completed by the Planning Commission to when it's adopted can take several months. So just to be aware of that. For Regional Planning Commission approval of the town plan and confirmation of the planning process, it's important to keep in mind that towns are not required to have the RPC approve their town plans and confirm the planning process. It does allow the town to be eligible for certain state grants, and it makes for more competitive grant applications. So when we receive town plans, we are reviewing those to make sure that they're consistent with those statewide planning goals that we went over. We're looking for compatibility with our regional plan. We're looking at if it's compatible with approved plans of other towns in the region. And we're making sure that the plan includes those required plan elements. And for the confirmation of the planning process, so this is more of the planning process goals that the state has. So we're confirming that the town is engaged in that continuing planning process that will result in a plan that's consistent with the state planning goals, engaged in a process to implement its municipal plan, so it's working on its implementation program, and the town is maintaining efforts to provide local funds for municipal and regional planning purposes. I will mention too that we are happy to look at kind of do an informal review of town plans before the Planning Commission schedules their public hearing to make sure that all the required plan elements are included That's not the formal RPC approval process, but we're happy to take a quick look at plans just to make sure nothing is missing. So that's the last slide I have for this section. Before I move on to the next section, I just wanted to see if there were any questions. And if you have any questions, just because it's hard to see everyone on the call, feel free to just unmute yourself and jump in if you have a question. And we'll also have time for questions at the end too.
Hello, Matt. This is Cassandra. You can call me Cassie. New to the Westminster area and will be part of the planning process there. There's a lot of information I'd like to get my hands on to review, like the regional town plan, the town plans that would apply that have been approved that would apply to the Westminster area, floodplain maps, I'd like a copy of this presentation if possible because I'd be referring back to it. So those are a lot of documents I would like to see. I actually used to work with a land use attorney in San Francisco and for 6 years. And so I'm very literal and legal in how I look at things. So
yeah, so that the presentation will be I'll send the slides out, and the presentation will also be, the slides will be on the website, WRC's website, as well as the recording. Our regional plan, our current regional plan, is on WRC's website. Our website also includes a separate page for each town in our region, which has a link to the current town plan for each town. And so, but if you have any difficulty finding any of that, you can always contact me and I can get you that information.
Perfect. And Cassandra, Matt,
yes.
Westminster.
Yes,
be glad to work with you. I'm on the planning commission. I can help you.
Excellent. So I'm looking forward to this.
Yeah. Great. Thank you for that question. Okay, so I'll move on. I'll keep moving ahead here. And I'm just going to turn my video off as I'm presenting. So the next section, we'll be talking about just ways that the town plan is implemented. So so you've adopted your plan, and the next step is implementation. And there are two main categories. There's regulatory implementation and non-regulatory. So for regulatory implementation, that can include zoning and subdivision bylaws, flood hazard and fluvial erosion bylaws, other local ordinances that are allowed to be adopted under statute. Non-regulatory implementation includes a lot of different things that could just be improving public facilities. It could be informing and engaging citizens, providing educational training resources for residents. It could be forming advisory committees to look at issues in more details. It could be completing additional studies and plans. Often in the town planning process, we will identify kind of an issue that needs further study that can't be fully addressed in the town plan document. And so that's one way to implement the plan. It can also be through supporting land conservation efforts, for example, for areas with important and critical natural resources. That's another non-regulatory tool. So this slide looks at types of regulatory review, just very broadly. So for zoning, there are permitted uses. Those are uses that are allowed as of right in a zoning district. They may be subject to site plan review, but they do not require conditional use approval. Conditional uses can be allowed if certain criteria are met. For a conditional use that requires approval either by your zoning board or your DRB, depending on how your town is structured. And for conditional uses, this is where the town is regulating potential external impacts from that use. So that could be impacts to community character, impacts to public facilities, traffic. So these are uses that generally you want to see, but there are some potential impacts that you want to make sure are addressed before allowing that use. Site plan review regulations establish design standards for parking, landscaping, lighting, screening, other site criteria such as that. Site plan review, you can require site plan review except for single family or two family dwellings. And you can apply site plan review to conditional and permitted uses. Variance is a deviation from the underlying zoning standards. So if someone is looking to build within a required setback area, for example, and there are very strict statutory standards for when a town can grant a variance. The waiver process allows towns to adopt more flexible local standards, so standards that are more flexible than the variance criteria. But these are for dimensional standards. So again, for the setback issue, a building within the setback, if a town has a local waiver process, then an applicant could apply for a waiver instead of a variance. And a town can come up with its own criteria for when it will grant a waiver too. And those can be developed, specifically for the municipality. And then plan unit developments allow for flexible design for larger scale residential developments and also for commercial developments. So for residential developments, often you'll see homes that are clustered together on a smaller area of land, leaving more area as open space or conservation land. For commercial projects, that might be a larger scale commercial project that covers multiple properties, and you're kind of trying to create a design for a larger site that spans multiple lots. And then subdivision regulations control how land is divided. So that can be divided into smaller lots. It could include merging properties. It could include a boundary line adjustment between two neighbors, just trying to make a small change to property lines. And the subdivision regulations allow a town to better control how land is divided up and have specific requirements in terms of how the dimensions of lots or how lots are laid out, public facilities, road design, things like that. Probably many of you are familiar with how zoning works, but for those that are newer to planning, I just want to go over briefly some basics about zoning. So zoning is used to regulate the location, type, and density of development and land uses through the creation of zoning districts. I tell towns there's not one right way to do zoning. It really depends on your community and its goals. There are statute requirements for how zoning bylaws need to be established and set up, and things that towns must do or cannot do in their zoning. But You know, some towns have very detailed zoning, and some towns have very simple zoning, and it kind of depends on how the community wants to approach it. The general organization of zoning bylaws, you have your zoning districts. So those are, you know, residential districts, commercial districts, maybe conservation districts, and the whole town is mapped out and divided into those different districts. Then you'll have general regulations that apply to all uses. So that's things like minimum lot size requirements, building height requirements, setbacks. And you may have standards for specific types of uses, and often those are your uses that are listed as conditional uses, where you want to have additional standards and requirements, and so those should be laid out in your zoning bylaws. And then the bylaws also cover the review process and administrative requirements, so people understand what they need to do to get approval, and that's clear and transparent. Then you'll have a definitions section defining the different terms, and then the zoning map is also part of your zoning bylaws, so people are able to identify which district a property falls in. So why should towns consider to have local land use regulations? There are many reasons. They can help promote that compact, walkable development, trying to focus development in those areas where you want to see development and you have the public facilities to support it. At the same time, you can protect important natural resource areas by excluding or limiting development. It's helpful to minimize fragmentation of farmland and also forest lands, both for agriculture and for forestry. We really need to maintain those larger blocks of land to make those activities viable. You can use it to incentivize affordable housing, so create, towns can develop their own density bonuses or other ways to encourage certain types of housing. It encourages the efficient use of infrastructure. So if you're really directing growth and development in areas the town already has roads, and if you have water and wastewater, then you're using your existing infrastructure and not expanding it to support new growth. You can ensure compatibility with the historic character of the town, establish safe and vehicular and pedestrian circulation, and make communities more flood resilient. So land use regulations are telling people what they can and cannot do with their property. It's always important to keep in mind that the land use regulations cannot deprive a landowner of all reasonable use of the property. And town land use regulations can only regulate what's enabled in state statute, again, because the state is a Dillon's rule state. And so Chapter 117, the required provisions and prohibited effects and limitations, that really spells out what towns can and cannot do. So just for example, towns are required to provide equal treatment of housing and required provisions for affordable housing. There are provisions in statute addressing home occupations, needing to provide for childcare. Statute also talks about accessory on farm businesses and protecting those. So it's important to keep in mind in developing or amending zoning bylaws to refer back to statute to make sure that your zoning is complying with those statute requirements. So one question we often get is, what is the difference between bylaws and ordinances? So bylaws are regulatory tools for related to land use. So those are adopted and enforced under Chapter 117 and statute. That includes zoning, subdivision, site plan review regulations. Ordinances are allowed under a different section in statute, which is included on the slide here. So that's chapter 59. And a select board can adopt an ordinance for any purpose authorized by state law. So most often it's animal control, a noise ordinance, an ordinance related to town highways. So that might be controlling where access can be put in, curb cuts, things like that. And ordinances are enforced under Judicial Bureau or criminal in the Superior Court. So towns can have bylaws and ordinances, and both of those can be used to implement your town plan. And for non-regulatory implementation, so this complements the regulatory tools. So Chapter 117 specifically authorizes towns to do capital budgets and programs, so planning out for municipal facilities, town roads, water and wastewater updates if the town has those facilities, tax stabilization contracts, purchasing and accepting development rights. That's often for land conservation. If a property owner might work with a town to kind of accept and take the development rights for conserving a piece of land. Towns can develop supporting plans. They can appoint advisory commissions and complete other projects and studies. And so this is not a comprehensive list, but these are specific tools that are included in Chapter 117. So those are just some implementation ideas. But before I go on to the next section, looking at roles and responsibilities, I want to just pause again to see if there are any questions. Okay. So the next section looks at different roles and responsibilities within the town when it comes to land use planning and regulations. So generally, we think about roles and responsibilities in these three categories. There's the legislative category, so that's writing a town plan or zoning bylaw and adopting that. So that's the process of creating and adopting a law. Quasi-judicial is the review and permitting process of that. Those are your boards that are making decisions based on the bylaws you have adopted. So that's more, we refer to as quasi-judicial, that action. And then there's administrative, which is the municipal staff within the town. And they can issue or deny a permit, again, based on the work done at the legislative level in writing and adopting laws. And this breaks it down further. So in this, again, kind of.
This is Tabby Friedman. I just wanted to double check on the appointment that I have. Is it tomorrow at 8?
There we go. For local roles and responsibilities, so your legislative body is your select board, and underneath that, towns can be set up in different ways. The Planning Commission has that legislative function. The Planning Commission is responsible for developing the town plan. It's adopted by the select board, but the Planning Commission develops it. The Planning Commission is also responsible for developing zoning bylaws and amending zoning bylaws. Under quasi judicial, towns will either have a development review board that handles all the quasi judicial responsibilities, or a town will have a zoning board of adjustment that handles some of those actions, and a planning commission that handles others. And I'll get into that in the next slide or two. And then for administrative, that's your zoning administrator. That's the municipal staff person. So the legislative function, I covered some of this, but the planning commission, again, prepares the municipal plan, prepares the zoning and development regulations. They can prepare or edit the capital budget and program. They can also work on other studies. The legislative body, your select board, they review and they can edit the municipal plan that is submitted by the planning commission, and they either adopt it or they can send it to voters for adoption. The select board also reviews and can edit zoning bylaws and development regulations, and either adopts them or sends them to the voters. One thing to note, some of you might be aware of this with the Home Act that was passed by the legislature last year. Rural towns can no longer vote to adopt bylaws by Australian ballot, but a select board can still forward zoning bylaws to the voters to vote on. Most of our towns don't have that Australian ballot requirement for zoning bylaws, but some do. And then the legislative body can also prepare and adopt the capital budget and program. So this slide helps break down the two ways of structure, the two ways a town might be structured when it comes to the quasi judicial role. So if you have a development review board, they are reviewing site plans, subdivisions, conditional uses, approving lots without frontage, variances and waivers, and handling any appeals of zoning administrator decisions. Or towns might still have the planning commission ZBA structure, where the planning commission, in addition to those legislative, the legislative role, also reviews site plans, subdivisions, and lots without frontage. But it's the zoning board of adjustment that handles conditional uses, variances and waivers, and appeals of decisions by the ZA. For the administrative function, the zoning administrator issues zoning permits for projects that may not require approval by a DRB, planning commission, or ZBA, or issuing those permits after a project has received those approvals from the required board or committee or commission. Zoning administrators can conduct enforcement, and they also assist applicants just with the permitting and development process. And depending on how this town is set up, they may provide staff support and assistance to a DRB, planning commission, or ZBA. Bill, did you have a question?
Yes. How does the zoning administrator conduct enforcement? If there's someone who contests an issue or doesn't seem to be adhering to a zoning regulation, what options does the ZA have?
Yeah, I think most towns have procedures for that in their zoning bylaws. For what happens if someone's not following a following what's approved in the permit. It might be in the bylaws, or it might be kind of in procedures that the town has adopted. But that's something I'm happy to follow up with you on that, Bill, just with some more details, because it is there's a lot of information to share there. But I think it's important just to have procedures in place, so that people understand what steps the town will take in terms of enforcement, and so a zoning administrator knows what their role and responsibilities are. But it is one of the areas that is challenging, is that area of enforcement.
Okay, thanks. We'll talk more. Thank you.
Yeah. And then when it comes to regulatory decisions, regulatory decisions by your DRB or ZBA or Planning Commission need to be issued in writing. They need to include a statement of the factual basis on which the appropriate panel has made its conclusion, and a statement of the conclusions. It must be based on the review standards in the regulations. So you need to refer back to your zoning bylaws in making that decision. Some towns keep very detailed minutes, and that might be sufficient if it contains the necessary information. But it can be easier just to do it in a separate document to make sure that you're really providing all the required information. The quasi-judicial panel, once they adjourn the public hearing, they need to issue a decision within 45 days. If they don't do that, then the proposal is deemed approved. So it's really important to keep track of that 45-day deadline, and making sure that decisions are made within that time period. And it's important to remember too that decisions don't need to be made the day of the hearing. So I think it's important for these panels to take time in reviewing a project and issuing their decision, but still always keeping in mind making a decision within 45 days. For appeals, so appeals under Chapter 117 can either be at the local level or state level. So a decision made by the zoning administrator, if someone wants to appeal that, that gets appealed to the DRB or the ZBA. A decision by a board gets appealed to the environmental court. So who has a right to appeal under proceedings? The applicant, the town or an adjoining town, property owners in the immediate area of the proposal, any 10 persons, and that can be a combination of voters, residents, or property owners within the town, any department or administrative subdivision of the state that owns property or any interest in property in town, or the Agency of Commerce and Community Development. So only interested persons who have participated in the process may appeal. And it's important to note too that appeals. So for affordable housing projects, if a panel determines that that project is compatible with the character of the area where the project is proposed, you cannot appeal it just based on the character of the project. So that's one thing to note. And then you can also not appeal based on character for any residential development within a designated downtown neighborhood development area or growth center. So for our region, Brattleboro, Wilmington, and Bellows Falls have designated downtowns. And I know Putney has neighborhood development area, and I think Brattleboro has a neighborhood development area. I see, let's see, Rhonda
Matt,
had,
Matt, can I ask a question?
yeah,
This is Esther from the town of Londonderry. I'm wondering about who is party to a decision. Does that mean they need to be part of the DRB hearing in order to be party?
that's my understanding, is that they need to participate in the public hearing. So it's to be an interested party, right? You need to be involved in the process versus appealing a decision and not participating in the process. That's my understanding.
Thank you. That's
Yeah.
mine as well. I just needed to check.
Yeah, and I see Rhonda Smith had a question about what does it mean by property owners in the immediate neighborhood of the subject proposal. That's a good question. I'm not sure the exact definition on that. I would need to refer back to the statute, which is shown here, the 4465B. So I know that provides more specific definition for the individuals that can appeal a decision. But I'm sorry, I don't have that off the top of my head. And there's a question about the affordable housing. Yeah, for affordable housing, there is a definition in state statute about a definition for affordable housing. So here where it's talking about that an appeal cannot include the character of the area affected if the project has a residential component that includes affordable housing, that you would refer back to the definition and statute for affordable housing. So there's a technical definition for affordable housing based on income eligibility, who is able to afford that housing based on area media income. But then there's affordable housing just broadly, and so that is affordable housing as defined in statute. And before I go to the last section on meetings, hearings, and due process, are there any other questions about roles and responsibilities? Okay, if not, I'll keep going, and I probably have about 10 more minutes or so, and then we'll have a little time for questions at the end too. So just to talk about the different types of meetings and hearings that a town might have related to planning and zoning. So this talks about meetings, legislative hearings, and quasi-judicial hearings, and there are different. I'll get on the next slide. I'll get into the different requirements for these types of meetings, but it's good to keep in mind the type of meeting that you're having, because there are different statute requirements for providing notice about those meetings. So a regular meeting, all public bodies hold public meetings, select boards, planning commissions, conservation commissions. You're discussing business, you may be taking actions. Generally, these are legislative, so You're going to hold meetings as you're talking about your town plan update, reviewing drafts, talking about zoning changes, reviewing drafts of zoning changes. Those you're talking about the legislative process and developing plans and regulations. Legislative hearings. This is when you would hold a public hearing, required public hearings, either on your town plan or a zoning bylaw update. And here, you can take public comments during regular meetings as well. You might invite members of the public to attend those meetings, but the legislative hearing is the more formal occasion for receiving public comments on those bylaw changes or a new town plan. And those are held by the Planning Commission and the Select Board. And a quasi-judicial public hearing. This is the public hearing. You hear from the applicant, you hear from other parties that are seeking board approval or wanting to comment on a proposed project. And so that's, Planning Commission, ZBA, or the Development Review Board. So for public notice requirements, and I would recommend, with these notice requirements, it's very important to follow these notice requirements. So always refer back to statute 2. This is kind of a high-level summary of these notice requirements. But make sure you're following them, and they're different for each type of meeting, which can make it confusing. So just for your regular meetings, you need to provide at least 48 hours notice, and you need to post the agenda in or near the town office and 2 other designated places in the community. For legislative hearings, so there are the requirements for a public hearing for a town plan and for zoning bylaws, or those requirements are found in different places in statute. And that's for updates and amendments as well. So for any update or amendment to your town plan or your zoning bylaws, you need to provide at least 15 days notice for those hearings. It needs to be published in the newspaper of record in your town. It needs to be posted in 3 or more public places. And then certified mailing is also required. And one other thing I had mentioned earlier, for legislative hearings, the Planning Commission is required to provide that 30 days notice to adjacent towns and the state and the RPC when it's 30 days notice of their public hearing for a town plan amendment or update. So keep that in mind too. That's in addition to the 15 days notice as described here. And there are provisions in statute that allow for electronic distribution of public hearing notices to adjacent towns and to the Regional Planning Commission. And we're happy to receive electronic notices, but I would just recommend, if you're doing that notice by email to adjacent towns in the RPC, just that you request a confirmation from the town or from WRC that we received your town plan or your zoning bylaws that you're holding the hearing for. And for quasi-judicial hearings, so depending on the type of application, it's either a 7 or 15-day notice. And that is specified in that section of statute 4464. Similar to the legislative public hearings, you need to publish in the newspaper, post in 3 places, mail to the applicant and to the abutters, and then there also needs to be a notice that's posted within view of the nearest public right of way. And for public meetings and hearings, I just recommend to towns, there's discussion at the state legislature this year just about requirements for remote meetings, virtual meetings. And so just that's something just to keep aware of, that I'm not sure if any changes will be made, but it's something to keep aware of, that requirements for remote meetings may change in the upcoming years. That's just something to keep aware of. Go ahead, Bill. Did you have a question?
I do. Does posting a notice on the town website, which is available to the public, is that considered posting? Is that one of the 3 places? Or do you have to post it physically in 3 places and on the town website?
That's a good question. I don't know the answer to that, unfortunately.
Yep, no problem.
Yeah,
Okay.
thanks.
Hey, Matt, I'm sorry, I do not have the hand raise.
Oh, sure. Go ahead,
thingy.
jump in.
Does the mailings to abutters and applicants need to be by certified mail?
I would have to, I would just have to check what it says exactly in statute. I know for the legislative hearings for town plans and zoning bylaws, if you're not doing those electronically, it does say certified mail. And I can't recall if it's certified mail also for the quasi judicial hearings. But that's something I'm happy to, if you want to follow up with me on that, I'm happy to help with that. I know it says in statute, I just forget what it says exactly.
You're allowed.
And just to quickly go over open meeting law requirements in Vermont. So we've talked about some of this already, but again, you need to meet those notice requirements for public meetings. The agenda needs to be available before the meeting in or near the municipal office, in at least 2 other designated places in town, and on the town website if the town has one. You need to provide for public participation. Minutes from the meeting, draft minutes need to be available within 5 days. And it's good to be proactive and address any complaints of violations. Things come up, and sometimes violations occur. So just working proactively to address those issues. And I have a link here just from Vermont League of Cities and Towns, their website with more information on open meeting law. VLCT has some very useful toolkits, and they offer regular trainings on open meeting law. So I would just encourage towns to, if you haven't, to review those toolkits or complete a training with VLCT on open meeting law. We could do a whole separate presentation just on open meeting requirements. So there's a lot to cover there. VLCT is a really good resource. For the quasi judicial public hearing, this is just a kind of a general process for how that goes. So the chair opens the hearing. The applicant is invited to present the proposal. The board members can ask questions at that point in relation to the conformance with specific provisions and land use regulations. Then there's an opportunity for comment from interested parties, members of the public who are in attendance. And then the chair once all the comments are made, the chair closes the public hearing and opens deliberations. And those deliberations can happen at a public meeting or in private, and I'll get to that on the next slide. And then the board makes a decision on the application and issues a written decision, again within that 45-day requirement. And so when you're opening a public hearing, quasi-judicial hearing, it's good to review with everyone the order of events, so people know when they will have a chance to participate, especially members of the public, so they know that the applicant will make a presentation first and then they'll have an opportunity. And it's also important to remind members of the public that once the public hearing is closed, unless the board reopens the public hearing, then they can't take any more public comments. And we recommend that boards they adopt rules of procedure and ethics policies that they have. And there at the end, I'll point you to some resources for some templates for rules of procedure. It's helpful to have copies of those available if people are interested in how different boards handle these hearings. Review the definition of interested persons and making sure that people are understanding what that means and meet that requirement. Some towns will administer an oath for interested persons that are participating in the process. And then, upfront too, requesting any disclosures of conflicts of interest or ex parte communications, which I'll get into that in a minute here too. The board chair, so the chair administers the agenda, keeps the board members focused on the issue, and ensures that the meeting is run efficiently. So a good chair will upfront state the question about what, depending on what the application is for, kind of what the board is considering and making their decision based on in the regulations. A chair will help facilitate that discussion between board members, just to make sure board members are participating. And then making sure that there's a resolution at the end after the discussion. So it might be kind of helping board members reach a motion on an application. For board members at the quasi-judicial hearing, so for a board member, they're looking at an application and evaluating it just based on your regulations. And so you should be listening to the testimony, listening to the applicant, members of the public, asking questions, always referring back to the regulations. You may have an idea or a thought about how a concern about a project, but it might be meeting the regulations. And so it's always important to refer back to what your regulations say. Be aware of conflicts of interest. It's not uncommon. It's a small community we live in, and so it's not uncommon for conflicts of interest to come up. Decisions need to be based on the evidence that's presented. So, that's what's in the application, what's presented at the public hearing. And then it's important not to prejudge an application or express your opinions about a pending case. You might have an idea about a proposal, but you should really not make a judgment before reviewing the application and participating in the hearing and hearing from other board members as well. So the deliberative session, this is what happens after the public hearing is closed. So deliberative sessions are, so this occurs after the public hearing. They are exempt from open meeting law. There's not a requirement for notice or minutes. Some boards still do these as public meetings, choose private meetings. You don't need to reveal how board members voted, but then the board, just a reminder, the board has to issue its decision within 45 days of the close of the public hearing. So once you close the public hearing, that starts the 45-day clock. For conflicts of interest, so there are different types of conflicts of interest potentially. A board member could have a financial interest in a project, either direct or indirect. They may have some other personal interest in the project. They might have a known bias or prejudice. And then ex parte communication. So that refers to any communication between a board member and an applicant or someone who's interested in the outcomes of the proceeding. The conversations that are happening outside of a public meeting that are related to the application. So it's really important not to have any sort of communication about an application other than either at your public hearing or during that deliberative session with the other board members. And I think it's important just to keep in mind it can take a long time to build up public trust in kind of the development review process, but it really just takes one mistake when it comes to a conflict of interest to have people kind of question that. So I think if there's any doubt about a conflict of interest, it's best to recuse yourself to avoid any concerns about that. So having rules of procedure and ethics in place help. That allows you to kind of define what potential conflicts are, so you can refer back to that. Ex parte communication, it's difficult to avoid. Again, right, we're in a small community, we run into people. So always make sure, if you're not sure, just share at the beginning of a public hearing, I had this conversation with someone, I'm not sure if this would count as ex parte communication, but just to be transparent about that. Recuse yourself if it's necessary, and that's one reason why we have alternate members for boards, is if someone needs to recuse themselves, you have someone else who can step in.
Matt, another question.
Yeah.
If you close a hearing and go into private deliberations, but the board does not make a decision during that session, does the 45 days start when you close the hearing or when the board makes the decision?
So the 45 days starts when you close the public hearing.
Okay, thank you.
Yep. And so just in summary, this is kind of best practices for protecting the due process, which is providing the proper public notice so people are aware of the meeting, they know what's going to be discussed. Give people an opportunity to be heard. I think making sure people understand when it's time to provide public comments. I think we've all been at meetings where there's a topic that might be more controversial or heated. So I think also it's a challenge, but trying to possibly limit the amount of time people are able to provide comments if people are going on for a long time, or if there are more heated discussions, just trying to manage that process. So it's important to give people a chance to be heard, but that also needs to be done respectfully, and that process needs to be managed. And that's, you know, related to conducting an orderly proceeding, ensure the proper management of evidence. So keeping good records of application materials, what's shared during the public hearing, if there's, you know, additional information that's submitted by other interested parties, providing appropriate management of conflicts of interest too. So just understanding what those are potentially, and making sure that board members are transparent and upfront about potential conflicts. So this is a lot of information, obviously, to go over in a short amount of time. And there are a lot of great resources out there that provide a lot more details on this. So just to mention a couple, the state recently updated its planning manual a few years ago, and they have a very helpful document just about the town plan update process. So some of like the specific requirements that I went over, but also providing a strategy for how to think about the different sections in your town plan, and kind of issues to be thinking about. So that's a really helpful document if you are thinking about doing a town plan update soon. The essentials of local land use planning and regulation. This provides brief articles on a lot of different topics, including zoning and planned unit developments, and just some basic overview information that's really helpful. The plan and bylaw adoption tools. This lays out step by step what you need to do for adopting town plans and zoning bylaws, and it has checklists and forms you can fill out to make sure you're meeting all the notice requirement dates. So that's a helpful tool. And then the rules of procedure and ethics manual. So that's what I mentioned, just for boards to have their rules of procedures for meetings and how they conduct business. And that document includes templates that towns can use and kind of adopt and make revisions to for themselves. This is like I said, I'll share this presentation so you have these links. This is the link to statute, our link for Wyndham Regional, Vermont League of Cities and Towns, and then the Department of Housing and Community Development, and then my contact information as well. And my contact information is also on the WRC's website. So if there were a couple questions this afternoon that I didn't have the answers to, so I'm happy to follow up on those. And we are, like I said, we are a resource here if you have those types of technical questions. Again, there are some questions where they are more legal questions where we can offer kind of general guidance, but some questions are better for a town attorney. And I think with that, finishes my presentation. I appreciate everyone attending. And if I know we answered some questions during the presentation, but if there are any other questions, I'm happy to answer those.
I just want to say thank you, Matt. This has been very helpful.
Thanks, Bill. And just to mention too, you may have seen an email from us about a planners roundtable that we're holding in 2 weeks on May 16th. So it's another event I would encourage people to attend if they're able to. That will be from 12:30 to 2 at the Brooks Memorial Library in Brattleboro. We are providing lunch at that event. If you are planning on attending in person, if you could contact me by next Thursday, May 9th, just so we order the right amount of food. But we will have a remote option for that meeting too, if you're not able to join in person. But that's something we're looking to do more on a regular basis, hopefully twice a year, just kind of having a roundtable meeting that will include a shorter presentation from WRC staff, and then just a chance for planners and planning commission members, ZBA members in the region to get to know one another and kind of more informally talk about some of these topics, and just share ideas. So just a chance to see if there are any other thoughts or questions, but if not, thank you again for participating, and like I said, feel free to reach out if you ever have any questions.
Thank you.
And
Thank you.
enjoy the nice weather too.
Thanks.
Yeah. Okay. Take care, everyone.
Thank you very much. Have a good one.